Hey everybody, good morning. I'm JD Houvener, the owner here at Bold Patents Law Firm, and I'm here with you live. I'm a patent attorney, and I'm going to be answering questions from you first and foremost if you're live. I'll be also answering questions from our Avo.com community, so if you're from our Avo listeners, please hang in there. I'll put you just after we handle the live questions and our topic for the day, which is, of course, why I'm wearing green at St. Patrick's Day. So happy St. Patty's Day to all you out there celebrating. What I've got is a weekly show here. So if this is your first time tuning in, give us a like and share this with your folks on social. I'm here every week answering questions, hypothetical, situational issues about the process for what patent law is, the difference between patents and trade secrets, trademarks, and copyrights. So I've got a little bit of a agenda here. I've kind of gone through the introduction already. What I want to do is offer a link, okay? After maybe right now, or maybe as we're listening, you may have a question that comes up and it's specific to your invention. I do want to make sure to let you know this is not the forum to share a confidential question, okay? Don't put your invention down in the comments. Please do not, ask a question that's going to disclose your subject matter. Keep that confidential, right? If you want to move forward and have a detailed conversation, I encourage you to please do reach out to us and schedule a screening session. We call it a screening session because a lot of times inventors that are first time or those who are kind of getting into the process are not quite ready. And so I've trained a group of non-attorney advisors, we call them, to walk you through, are you ready? Is hiring a patent attorney the right thing for you now? And so one of the things that we do provide is a lot of good information. I've actually published a book, Bold Ideas, The Inventor's Guide to Patents. And this book has all the major pieces of what patent law is about. So I encourage you to get a copy of this. And I will include a free PDF download for anyone that takes action and schedules a screening session today. All right. So let's get to our topic of the day, which is St. Patrick's Day innovations. And I had to dig deep on this. I did find, unbelievably, a patent that I probably spent too much time on this morning looking at. And so I've got one good example of a St. Patty's Day invention. So what I'll do is show that to you guys, and we'll go from there. And I'll keep an eye on the chat. If you guys do have a question, please do put that into the live chat. I'll be posting that. I'll be getting to your question first. I think we do have an error on Facebook. I don't know what's happening there, so I apologize about that if you're on Facebook. So I think we're broadcasting across Google, which is their YouTube platform, as well as Facebook and Twitter through their Periscope. Okay, so let's do this. Let me share my screen, and we will take a look at this first patent. Okay, yeah. Excellent. So this is a patent to a Woon Kyung Lee. It's a U.S. patent, utility patent, granted in 2007. It is for a variety of four-leaf clover. Okay, you read that right. And a method for breeding the same. This inventor, actually there's several inventors here from Korea, have found a way to breed four-leaf clovers. I thought this was awesome. I mean, I spent a lot of my childhood, I don't know if any of you, and even some of my adulthood, to be real honest, looking for four-leaf clovers, right? Hunched over on the ground, digging through clover patches to just maybe find a four-leaf clover. This is astounding. I read through this. Now, real quickly, I was also surprised to see this was a utility patent, okay? Typically for a variety of plants, you'll see a PP, meaning a plant patent, indicated in the upper right. This is not a plant patent, so they've come up with a novel method for growing. Now, plant patents have to do with the actual plant itself, okay? And so that has to be shown to be unique. But what they've done here is they've been able to modify at the botanical level the traditional three-leaf clover. That's what I was reading. And import a lot of different methods and operations and chemicals to regrow the thing. and if Tor will constantly and consistently produce four-leaf clovers. So the pictures here are just awful. They really are. It's unbelievable that these pictures give the examiner enough information to be able to say, yep, that's a plant, because honestly it looks like abstract paintings to me. But black and white drawings are acceptable. There it is. My goodness, what are we looking at? So the invention here, as claimed, is down below here. We'll kind of scroll past some of the specification just to kind of give you an idea in terms of what this patent has rights on. Okay, here it is. So number one, they kind of hide the claims. A method of breeding a new variety of four-leaflet clover from a wild-type three-leaflet clover. I guess the Latin term is the Trifolium repens, L. The method comprising the steps, okay? Comprising the steps. That's a fancy term for, well, it's going to at least include these steps. And they've got steps A, B, C, and D with sub-steps as well. So it's quite lengthy. And so right away, I'm thinking, oh my goodness, this is a lot of steps. And if I'm also interested in producing a four-leaf clover, I'm going to be curious about, is there any way to produce this four-leaf clover and not follow this method, right? Because it's so specific. If there's any way to produce a four-leaf clover without following this method, I am not infringing, okay? So that is some of the problematic result of having a method claim. But let's see how they actually do it. And I won't get into too much detail, but I was just curious. So you get the stem from the regular three-leaf clovers. You just cut the stems at about 5 centimeters, remove it, transfer them into a conical flask, putting ethyl alcohol. Then you're going to clean the thing, to sterilize it with sodium oxygen chloride. I'm obviously not a chemistry major. Cutting them again a little shorter, about almost in half, to 2 to 3 millimeters. And then you're going to treat them with cold water and then this ethyl methane sulfonate. And that sort of, in a way, sterilizes them, gives them, you put more acid on it, and that's going to basically produce your four-leaf clover. Okay, but that wasn't enough. So once you get the four-leaf clovers, you have to complete these further steps of transplanting them into soil, which is, I guess, that's pretty classic soil, potting soil, with certain temperatures, and then you're going to be able to propagate. Basically to graft and to create what's called asexual reproducing the plant on its own. So in a lab setting, you can produce several or as many of these as you want. Pretty amazing. So they figured it out, how to make the four-leaf clover. So I was curious, and I did pull up some pictures. This is the Google translated Korean patent filing. And the Korean patent office, I guess, required them to provide some actual photos. So I was pretty curious. So this, I was like, wait, these are only 3 leaves. What is going on here? But this was just sort of showing the state of the art. So they're showing what I think most people that are watching, if there's anybody on at all, this is what you normally see. You're like, where are the 4-leaf clovers? Where are they? This is the classic, organic 3-leaf clover. What they've done is produce 4-leaf clovers. Look closely. These are all 4-leaf clovers. Pretty amazing. It's your lucky day. So how did they do it? Just by that process that I mentioned. So they put little stars on the 4th leaf that they've been able to produce. Pretty amazing. Pretty amazing. Different varieties there. All right, enough about that. But I wanted to at least have a fun little segment on 4-leaf clovers. No comments coming in yet, and I do apologize to those Facebook users. We're not seeing, for some reason, the comments I've sent out earlier weren't going through. Thanks for that like, Mike. Good to hear from you. So let's do this. Let me try again. I'll put the that link in to see if it goes through. because at least for my platform, I'm not able to show or see that it's getting sent out. Hey, there we go. All right, so there's that link. For anybody on Facebook, looks like things are finally rolling on Facebook side. The screening session is if you're ready to get started, you're curious about patenting, maybe you've got a new version for how to make your own four-leaf clover, send it, click on that link and you can schedule a free 30-minute session. And good, thanks Maya for letting us know Facebook is looking good on your end. All right, let's do this now. I wanna get to our AVO questions. And so I'll jump over there. AVO is a platform where I volunteer as an attorney to help answer questions related to intellectual property. And it's fun because the questions are usually pretty good. They come in anonymous, so there's no impropriety or confidentiality issues. There are 5 patent questions open this session. So I'm going to jump to these and I'll share my screen so you guys can see the questions yourself. All right. All right, so from Temple, Texas, just one day ago, this question came in. I have an invention I want to open source, but I can't afford the patent. I'm concerned that a company will patent it. I want everyone to be able to use it and make it without fear of someone else hoarding the royalty rights. All right, we got a real do-gooder. Excellent, and I think it's very noble. Patent is the wrong area of law for you, my friend. Patent law is about making money. It's about rewarding financially the inventor for providing information in exchange for getting an unlimited monopoly for up to 20 years. So for you, if your goal is really just to share the knowledge and get it out to as many people as possible and prevent anyone else from getting a patent on it, all you have to do is simply publish it, okay? And you can do what's called, a defensive publication. You might have heard of that term. Big companies do that a lot, where they think maybe a competitor may be on the verge of filing a patent application. They're going to just publish as loudly as they can what they think their competitors might get a patent on or seek protection for, because what that does is it provides definitive, open, public information that an examiner will be able to review. And if that was published, right, if what you've demonstrated, you've sent that out to the folks in the industry, that when they file their patent application, it's no longer new, which is the first criteria to getting a patent granted. It's not new, right? They weren't the first ones to come up with it because the publication that came before them fully explained it. So there are ways to make sure that your publication is going to be at the right level, and we can help with a defensive type publication. You want to make sure that it gets to and is well-known publishers in the specific industry that you're looking to prevent bigger players or even smaller players from being able to secure patent rights. Okay, so thanks for that question. This one comes out of Manassas Park, Virginia. Is there a law that will allow me to be the sole seller of a product? Patent law. I want to start my own small business selling a certain product. I want to know if there's any way that I could be the sole seller of a certain product. In a couple ways come to mind. Certainly, if that product is novel, is not an obvious version of something else that's come before it, and has utility or has an aesthetic design that's unique about it, you can seek patent protection for it. And that will allow you to initially be the only one in the US to make it, sell it, and import it. Okay, make it, use it, and sell it. So those are, that's option one. Is go look for a potential patent for your product if it's new, right, if it's novel. The second way is, like a lot of businesses do, is you have some trade secrets. Okay, you've got some ways of producing it, right? Maybe you've got a way that's very inexpensive, or you can do that very efficiently. And you've got a certain, maybe a certain add-on to your product that is not really known in the future. You're able to get an advantage, or your product is superior, but it's not necessarily, something that's obvious to the consumer, and might even be very difficult, if not impossible, to reverse engineer. So you can keep that as a trade secret. Okay? So keep the information within your company confidential, is it certainly through employment contracts or through a non-disclosure agreement, on ways you can have a competitive advantage and truly be the only one to have that product because you and your company are the only ones that have that secret sauce. All right. So thanks for your question there. Let's jump back and see if we have any live questions. Okay, looks like the sound dropped off a little bit. What I'll do is I'll change the microphone. Check, check. Hopefully audio is okay. I'm actually adjust the mic volume. So we'll have to just make that. We'll do some testing on that later. Sorry for the audio dropping off. This question is out of Burbank, California. Can I avoid resubmitting figures for a continuation in part application by referring to ones in the parent application? I just reshared here. So a continuation in part application is an application that once you file your first non-provisional, it is an application that part of it is going to be based on the original specifications, originally what was filed in that parent filing, but you're going to be claiming new subject matter or a different set of claims. So when you're submitting that type of an application, which is really a separate app, it'll be a child application of the parent. This question is, can I submit just the claims and spec without figures? And the whole point of figures, okay? Figures are, the technical term is you must include them if it's required to fully enable the claimed invention. So if there are aspects of your invention that really can only be shown and not described, right? If there are angles or shading or some features, structure, elements, that it's going to be very challenging to be able to help an examiner understand with words alone, then a figure is required. And in almost every case, it makes sense to include figures when you're making claims for physical embodiments. And even for flow charts, right, for processes, it's so wonderful to be able to have a very clear diagram which accompanies the written, steps and methods. So I think it's fair to say that it's required in almost every sense, even for a continuation in part. If those new claims, of course, are going to require having some physical elements shown or even a process shown as well. Hope it helps answer your question. All right. So we're looking at, we'll do one more, and then we'll jump over and do a trademark question. All right, when can I file a continuation in part application after a final office action rejection? My patent application got a final office action rejection with a 3 months to reply, and that is passed. But the examiner failed to conduct a full Graham analysis for this obviousness rejection. I'm going to pay the USPTO for replying within 2 months time extension and submit a reply. My arguments are going to be that they didn't properly frame the analysis. And since no amendments were made, this final argument is put forward by me. Honestly, this is a bit complicated. The question being asked here is not going to be one that I can answer right now. This is a little bit too detailed. I need to see the office action that the examiner sent in to really answer what you're asking. Because it's hard to tell whether they've actually properly analyzed the question or not. All right. Well, listen, we have a major sound issue, so we're going to bounce back. And whenever I share screen, I think that's when we have major sound issues. So, all right, you guys. Well, it's been good to see you. I don't think we have any live questions this time. So what I'll do is wish you guys a happy St. Patty's Day, and we'll check the audio and the technology here behind the scenes for next week.
But again, it's good to see you guys, and thanks for having me on. I'm here every week, every Wednesday at 9 a.m. Pacific and noon on the East Coast. Have a good day, you guys. Go big, go bold.